What we're going to talk about today is the religion clauses, the first part of the First Amendment. So let's turn to that First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. That sounds pretty simple. One justice, Hugo Black, who was a prominent justice of the 20th century, said, it's very easy to understand the First Amendment. I learned in grade 2 that no means no. No law can Congress pass that abridges the freedom of speech or freedom of press, or establishes religion, or denies someone the free exercise of religion. It's no means no. That idea of no means no came into force, certainly with the guarantee of freedom of press and freedom of speech. Today, there's basically nothing the government can do, whether we're talking about the federal government, as originally designed in the First Amendment, or the states through the process which is called incorporation, by which the guarantees of the Bill of Rights have been carried over onto the states. So now we really should read that First Amendment. Neither Congress nor any state may, so forth and so on. So if we're talking about press or talking about speech, government, if it tries to limit speech or if it limits press, the court is going to find it unconstitutional. Whether we're talking about conservative justices, liberal judges, Republicans, Democrats, there's very little difference on this issue. It's a whole different kettle of fish, however, when we talk about what is an establishment of religion, what is free exercise, or what are the guarantees of people against an establishment or for free exercise. And what the two reasons for this, two causes of the problem that the court has had in understanding the Establishment Clause and the Free Exercise Clause. The first one is definitional. What the heck does an establishment mean? Well, you could say, well, it means what they have in the United Kingdom. King Charles III is the head of the Church of England. It is the established church. And there are established churches in the Scandinavian countries. Greece, the Greek Orthodox Church is the established church. And today in Russia, the Orthodox Church is essentially an established church. It gets preference over other religions, or it is, in fact, it is supported by the government. That's one idea of establishment. Is that the only thing establishment means? So we have, what does establishment mean? Free exercise. Again, what does free exercise mean? Does it mean, as we're going to see in one of the early cases, simply that you have the right to believe anything? Or does it mean that you can practice anything? I mean, exercise is physical. It's doing something. So is it just belief, or is it ceremonies, or is it acting out of belief? That's one problem. And there's also a related problem. What the heck is religion? I mean, you can say, yes, there's Presbyterianism, the Catholicism, Judaism, they're religions. But what about the individual who has his or her own religious belief, individual beliefs? Is that a religion? Is that given the same protection as Catholicism, as Episcopalianism, atheism? Is that a religion? That's one area that causes problems. The second area that causes problems is the potential of a conflict between the Free Exercise Clause and the Establishment Clause. If you say, because of your beliefs that you are opposed to war, that you should be exempt from military service, doesn't that kind of establish the religion of the Society of Friends, or the Mennonites, the Amish, or some other religious denomination that believes that killing is wrong in all circumstances? Doesn't that establish them? Doesn't that give them a preference? If we have an absolute protection against establishment, no law means no law. Doesn't that interfere with people's free exercise? Conversely, if you go to give people the right to do anything based on religion, well, doesn't that kind of help religion? Doesn't that establish religion? Doesn't that give preference to religion? So these two issues, or these two problems, the definitional problem, trying to define what is an establishment, what is free exercise, and the issue of conflict between the two clauses, perhaps are the reason that we find that in the terms of the religion clauses, they've been the most difficult for the court to deal with. If you look at the Bill of Rights, The court decisions involving the Bill of Rights obviously have been controversial. Criminal procedure decisions were very controversial in the 60s and 70s. The requirement that police officers, when they stop someone, must give them certain information. If they detain them, that they have to inform them that they have a right to remain silent, that anything they say may be used against them. They have a right to an attorney, that if they cannot afford an attorney, one will be provided for them. That's certainly controversial. Some people disagreed with the court's decisions on obscenity, which pretty much allow anything to go today. But it's interesting that these issues that were controversial at one point are pretty well settled today. As I said earlier, there's very little dispute among individuals on the court between conservatives and liberals, Republicans and Democrats, activists and advocates of self-restraint in terms of the protections of freedom of speech and freedom of press. There's really no debate today in terms of the criminal procedure decisions. They're pretty well accepted. But when it comes to the religion clauses, that is not the case. And it's not from want of trying. In fact, the Supreme Court was forced to look at free exercise and establishment earlier than it did on any of the other guarantees of the Bill of Rights. In 1879, the Supreme Court found itself confronted with needing to interpret what free exercise meant in a case coming from Utah, case involving the practice of polygamy. Was that protected by free exercise? And in terms of the Establishment Clause, the court's first case involving the Establishment Clause came in 1899, a case involving a Catholic hospital in the District of Columbia. It was funded by the government, and someone challenged it as a violation of the Establishment Clause. So the court started looking at free exercise and establishment long before it looked at any other provision of the Bill of Rights. And it's continued. And what's happened, though, when you look at what it's done, one justice, late Justice Anthony Scalia, said if you look at the court's decisions involving free exercise and the non-establishment clause, what you've got is a Stygian bog. It's a mess. It doesn't make sense. In terms of free exercise, you look at free exercise. Well, an individual who is opposed to all wars can be exempted. That's by congressional statute. But what if an individual thinks, no, I don't believe always killing someone in war, self-defense, is wrong. I believe it's only wrong if it's an unjust war. Well, the court says, that's sorry for you. You can't pick and choose. But if you take it all off, then you're all right. Well, what about this person who believes all killing is wrong, all wars are wrong? So I don't want to pay that portion of my taxes that go to fund wars or either future wars or past wars. I don't want to do that. That violates my religious belief. I'm supporting it. Well, the court says, no, you can't do that. You can be exempt from service, but you can't be exempt from paying those taxes. Or another issue in terms of free exercise. The court holds, and we'll see this later, that an individual who believes that the Sabbath is not Sunday, but Saturday, a Seventh-day Adventist, that she is allowed to get unemployment compensation, even though she will not make herself available for work on Saturday. She gets it. Now, if you don't want to make yourself available for work on Saturday because you've had a hangover from Friday, sorry, that doesn't cut it. Well, maybe you can say, well, my religion said let's drink and be happy. Well, okay, so Adele Sherbet gets the unemployment compensation. But then there's a guy named Braunfeld. Now, Braunfeld is an Orthodox Jew. He's running a men's haberdashery. I'm sure how old I am. That's a place that sells men's clothing, okay? He, as an Orthodox Jew, closes his business at Friday and sundown, doesn't open until Saturday and sundown. But the state says you can't open on Sunday. Well, if he follows both his religious prescription and the state prescription, the guy has to close his store sundown on Friday and is closed until Monday morning. That's not a great, I'm not a business professor, but that's not a great way to sell men's clothing. You're going to go bankrupt quite quickly. So he goes to the Supreme Court and says, no, sorry, tough luck. Free exercise, therefore, it doesn't cut it. Well, really, who's in the worst shape? Sure, Adele Sherbet's going to get a job sometime. If you got full employment or the unemployment rate that is down as low as it is today, she's going to get a job. Brownfield's out of business. You cannot run a men's clothing store that's closed the entire weekend. You're just out of it. Does that make sense? In terms of the Establishment Clause, the cases are even weirder. The court has held that you can loan students in religious schools books, even those that we know those books never go back to the public school book depository. They always stay in the religious school. You can do that, but you cannot provide maps. Someone said, well, there's a solution to that. The school should just buy atlases and give every student an atlas. That doesn't, come on. Or if you can send a public employee to a religious school to help with students who have learning disabilities. But that person has to give that instruction in a trailer outside the public school. So the kids have to come from the school but he or she cannot go into the public school and give the same instruction. Does it on the property, within the property perimeter, in a trailer, that's okay. They don't make much sense. I mean, in terms of the issues of obscenity, which at one point plagued the Supreme Court, Justice Potter Stewart said, I can't define it, but I know it when I see it. With this, you can't even say that you know it when you see it. It's just total confusion. And yet what I like to put to you is that while it sounds extremely, these decisions seem very confused. It's not from wanton trying. The court has certainly worked at this issue, as I say, in terms of free exercise since the Mormon case, the Establishment Clause since the turn of the 20th century in terms of the Catholic hospital in the District of Columbia, and has had even more cases to work with after the Supreme Court incorporated the free exercise and Establishment Clause issues onto the states. So now, as I say, you read the First Amendment, neither Congress nor any state. It doesn't come down with anything that's very clear. But I put it to you that while it might be confusing to the outside observer, to the justices themselves, they have, once they're on the court, or maybe some before they even get on the court, who come with a certain agenda, do have a particular position that they adhere to in terms of how they deal with the Free Exercise Clause and how they do with the Establishment Clause. Now, the terms that are usually used, the ones that you might be familiar with, are accommodationist and separationist. These two terms come from cases from just before the beginning of the Warren Court. Warren was appointed Chief Justice in 1953 by Dwight Eisenhower. They come from what's called the Vincent Court. We tend to name the court for the Chief Justice. In Everson versus Board of Education, Justice Hugo Black did two things. First of all, he held that the Establishment Clause now applied to the states. It was a case coming from New Jersey involving the provision of bus transportation to students going to private, non-profit schools. The court upheld it. But they talk about separation between church and state. So that decision is considered a separationist decision. In a subsequent decision involving a program by which teachers of religion went into public schools to give religious instruction, which was struck down as unconstitutional because it violated the walls of separation. That would be a separationist decision. In 1950, in another case involving religious education to kids in public schools, Justice William O. Douglas, usually an ally of Hugo Black, talked about the need to accommodate religion, that by allowing students to leave the public school during public school hours when they were required by state law to be in school, to go to churches, to go to synagogues for religious education, that was okay. That was an accommodation that was allowed by the Constitution. So we have these two terms, separationist and accommodations. And they tend to be very popularly used when we're dealing with the First Amendment to say that this justice is an accommodationist, this justice is a separationist. These two terms, however, really only reflect their position involving the non-establishment clause. Hugo Black says there should be a high impregnable wall between church and state. William O. Douglas says we are a religious people whose institutions presuppose a supreme being. We can make accommodations, but that's just involving the establishment. What about the free exercise clause? And what about the free exercise clause? If you look at the Supreme Court decisions on the religion clauses, overwhelmingly, by at least 2-1, they involve the establishment clause. These are the ones that get most of the attention. Is that justified? Is there a balance between the two? There's a potential conflict. How do you settle that conflict? Do you settle in favor of free exercise or establishment? Lawrence Tribe, Akhil Amar, two very liberal scholars, one teaching the Tribe at Harvard, the other at Yale, argued that the basic goal of the religion clauses is religious liberty, that free exercise is the more important of the two.